What was it like inside that courtroom?
It was quite tense, right? So Jack Smith is on the other side of the courtroom, and he has basically 3 or 4 rows of his lawyers from his office. Donald Trump, on the other hand, had a smaller group. They actually had an extra role they weren't able to fill up. But essentially, Donald Trump walked in 5 minutes before this proceeding got underway. He unbuttoned his jacket, sat down, had a little small talk with his lawyers here. But he was quiet for most of the argument that his lawyers were making directly. He got a little bit more animated and started writing notes on a yellow legal pad when it was time for the special counsel to make their arguments. So he heard some things he obviously didn't like there. But honestly, the thing that he got the most worked up about amidst all this legalese that probably went over his head is when his own lawyer, after Donald Trump had scribbled those yellow notes on rebuttal, had said essentially that Donald Trump was leading in all of the polls. And this was all about Joe Biden trying to keep him out of office. Just sort of a very sharp political argument is what Donald Trump liked the best. And when Donald Trump heard his lawyer make that argument, he sort of shook his head vigorously. And that was sort of the most animated that we saw him during this entire proceeding, Jose.
So there were the political arguments, but then, of course, the legal arguments that are key. Ryan, what were the main arguments from each side?
So essentially, there were really tough questioning that we saw come from the judges here about whether or not how far this immunity that Donald Trump believes he had would extend. There were, questions about whether or not this could apply to someone who ordered SEAL Team 6 to kill their political rivals. And they sort of danced around that as much as they possibly could. But, ultimately said that unless Donald Trump or a theoretical president, let's say, unless a theoretical president was actually impeached and found guilty, then they could not prosecute him. Basically, Judge Pan was sort of trying to narrow down Donald Trump's lawyers to basically say that, to admit that basically what this boils down to is their argument that the only way that a president can be prosecuted is if he is impeached and found guilty by the Senate. The judges could decide on that, and they wanted it to boil down to whether that is the whole argument, because, I think in their view, in the judges' view, the sort of consensus we're coming to is that that's not what the rule is, that there are other ways for individuals to be held accountable other than just being being impeached and then found guilty by the Senate, Jose.
Yeah, Joyce, it was interesting to see and hear the judges. They seemed skeptical of Trump's lawyers' argument, especially the issue of that a president is essentially immune unless he is impeached, found guilty by the Senate. What did you make of those arguments?
Right. I think this panel very clearly did not buy the former president's immunity argument. The most difficult questions that they lobbed at the government lawyers were, okay, if we rule for you, what does the rule look like going forward? Are presidents prosecutable for everything that they do while they're in office? And so there was a fairly detailed conversation where the government lawyer said, look, you don't have to decide that question for all time. You can carve that out. You can say that there might be some immunity in very specific questions. For instance, when a president relies on his lawyer's advice to launch a drone strike. But here it's clear that there's no immunity. And the government did something very clever, I think possibly an argument for the Supreme Court down the road. They referenced one of the amicus briefs where some conservative lawyers argued this case could simply be decided as a matter of the executive vesting clause of the Constitution, which says that there's an interest, that there's a governmental interest in making sure following each election that the government is passed on, that control of the White House is passed on to the winner of that election, executive vesting. And so you might say that here, where a former president interferes with that specific clause, there is no immunity. And that view, if adopted, I think the panel decision, frankly, will be broader, saying that there's no immunity. But perhaps that very limited basis for ruling that there's no immunity will be attractive to the Supreme Court.
Yeah, and Andrew, bringing up something Ryan just mentioned, the judges asked Trump's lawyer hypothetical questions about whether a president can be prosecuted for certain acts. Here's one of those questions and the response from Trump's attorneys. Take a listen.
Could a president who ordered SEAL Team 6 to assassinate a political rival who was not impeached, would he be subject to criminal prosecution?
If he were impeached and convicted first. And
so your answer is no.
My answer is qualified yes. There's a political process that would have to occur under the structure of our Constitution, which would require impeachment and conviction by the Senate.
So that's interesting, Andrew, that the fact is that Trump's attorney is essentially saying, yes, essentially a president could order the assassination of somebody, a politician, but only prosecuted if he is found to be guilty in a conviction by the Senate. In other words, what do you make of that answer to that question?
Well, like Joyce, I think that there's not a single judge on the panel who was buying that. It was notable that none of the judges really asked the government about that sort of impeachment prerequisite. That is just a very, very strained argument. And if you step back outside of the legal world that Joyce and I live in, and you think about what just happened today, it is really remarkable that you have a former president saying to a court that they can actually order the murder of somebody. And as long as they avoid being impeached and convicted, that's fine. They can't be prosecuted for it. And of course, there are many ways that somebody could avoid getting impeached and convicted. For instance, they could resign right after they committed that offense. Or if the murder was of your adversaries in the Senate, you could avoid being impeached and convicted. And I mean, it is such a preposterous argument. And it really is, I think, a real sign of the world we're in, where this kind of argument is, seeing the light of day. But I do think that there was no judge that was thinking that that is going to be the correct argument. I'm totally with Joyce that they're going to be trying to figure out how to fashion a rule that deals with what it is that the government is advocating, so that they can sort of do what they need to do here without totally binding future courts dealing with different factual scenarios.
And Joyce, I just want you to expand a little bit on what you were talking about, the implication or the insinuation very directly by Trump's attorneys that, well, this, if there is no immunity, then it would make it fair game for other groups, other panels, other judges to go after a former president for his decisions taken while in office.
Right, and this was the point that Trump's lawyer returned to again and again early in his argument. He kept throwing up examples of actions Democratic presidents had taken. For instance, Barack Obama signing off on drone strikes where civilians were killed, or some issues that occurred while Bill Clinton was in office, as though he were threatening, if this is the new rule going forward, then every Democratic president can expect to be prosecuted after they leave office. But Jose, the response to that, and it's one that the government offered, is that presidents don't direct the criminal justice system. And in fact, we live in a real rule of law world where there are a lot of procedural steps required before someone is indicted. Prosecutors behave according to ethical standards that bind them regardless of what party holds the White House. Grand juries review the evidence. Petit juries, trial juries, decide whether or not the government proves its case beyond a reasonable doubt. And then there's review by the courts following a conviction. And so this possible list of horribles that Trump's lawyers want to throw up if a president doesn't have immunity in Trump's situation really doesn't make sense if we do what Andrew suggests, and if we step back a little bit out of the legal world and use our common sense to think about where there should be presidential immunity. I think we can all land where this court is clearly landing, that one place where a president shouldn't have immunity is when he tries to interfere with the outcome of an election.
And so, Andrew, how quickly should we expect these judges to come to a decision, and what are the possible decisions they could come to?
That, to me, is the whole ball game. It's the question of the clock, because I think the ruling is going to be to support Judge Chutkan in one way or the other. I think that the data point that we have on timing is that this case was briefed and heard incredibly quickly. The briefs all went in by January 2nd. They heard the case today, a week later. I would be surprised if we did not have an opinion in a week, possibly 2 weeks. The issue is what kind of restrictions the court then places on the time frame for an appeal. So Donald Trump can do a couple things. One, he can seek en banc review. That is a review by the whole court. He could ask the panel also that heard it to rehear it. So those are ways to delay it within the D.C. Circuit. But what the D.C. Circuit panel today can do is say you only have a certain amount of time to do that. Or the way they would phrase it is the mandate. This is going back to the district court in X days, like 5 days, if you do not seek further review. So they can do things to sort of shorten up the time frame that Donald Trump has. Then obviously the other thing that can happen is Donald Trump can seek Supreme Court review. But again, the D.C. Circuit and the Supreme Court have the power to tighten up that time frame. That is why it was fascinating to me that at least 2 of the judges, possibly 3, were very interested in whether this was even this appeal by Donald Trump was even properly taken. In other words, whether the court should have heard this, because the normal rule, as Joyce knows, as being an experienced appellate lawyer, is the normal rule in a criminal case is that you only can appeal once the case there's a verdict in the case, at the end of the case. You don't get to do these sort of interim appeals. This is very much an exception, and the circuit was very interested in whether this was properly before the court to begin with. Why is that important? Because if it's not properly there, they can send it back to Judge Chutkan and say, you're green-lit, go forward.